Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. We talk a lot about custody issues, and in this day and age where people work remotely and they work from different places, to some degree the world has become a much smaller place, and we are seeing more and more custody cases involving parents who live in different jurisdictions. The question often is raised, how can I get custody here in Michigan of my kid when my kid's living in California? When my kid's in Utah, when my kid is in Atlanta, Georgia? How can I do that? Well, it presents challenges. Number one, the court always likes to keep a transition as easy as possible for a child, which means if the transition involves moving from Oak Park to Southfield, that presents one set of challenges, whereas if the court is faced with taking a child from California, moving the child to Michigan, that's a whole other set of challenges. That's a whole other environment that the child has to get used to. So it is potentially more challenging to get the court to grant you custody in that circumstance. But remember one thing, the court takes into account what's in the best interest of the child, and the mere geographics of where the child will end up is only part of that analysis. The most important thing the court is going to want to look into is, look, if we make the move and we change the order, giving dad the custody instead of mom, which could thereby causes the child to have to move from Atlanta, Georgia to West Bloomfield, Michigan. If we're going to do that, is it in the best interest of the child to do it? And here at the firm, we have many cases. We've succeeded in bringing a child from a different state and getting the court to order that the custody should be here. But remember one thing, the court doesn't do it just because it likes one parent more than the other. The court's going to do it based on what's in the best interest of the child. So the court's going to have to see something very hefty, very weighty in the way of evidence to support such a move, which means the court's not going to say, well, we're going to move the child from Michigan to Florida because the weather's better. The court's not going to do that. The court is rather going to look at different things. For example, if the current custodial parent in the nicer climate area like Florida, and there's a motion in Michigan to move it over, if that parent in Florida is a drug addict and an alcoholic all of a sudden, the court may very well say, you know what? It's in the best interest of the minor child to go to the other parent. The other parent's in Michigan, boom, child goes to Michigan. You see, the court is not just going to look at all the things in a vacuum without considering what is the impact of those factors on the child. Now, I used an example before. I said, well, the court's not just going to move from one jurisdiction to another because the weather's better. That's an example. But let's say the child is very asthmatic, and in the current custodial environment, the weather, though better, causes the child to constantly be reacting. The child is missing a lot of school. The child's constantly going to the emergency room. Child never had that problem living in Michigan. Never had that problem because somehow the climate here agreed with the child better. In that situation, the court could very well say, you know what? It's in the best interest of the child because of the climate, because of the health situation with the child. It's in the best interest to move back. So that's a circumstance where the court will take the factor into account, but the overwhelming analysis is what's in the best interest of the minor child. Now, if you have any questions about that, reach out, and of course, we'll be glad to help you out.